Happy Friday, everyone, and welcome to episode 7 of the Cult Brief podcast. My name is Kitt. I'm the staff attorney here at Cult, and I'm flying solo today. We have a few things to talk about, but I do want to let everyone know that we just had our summer seminar. We had some great speakers on agricultural tax, business, and transition planning. So if you weren't able to attend in person or online, we are going to have that up on our Tax Place soon. So for Tax Place members, you'll be able to see that. For the first time this year, we have video that goes with the audio, so you can see the speakers and the PowerPoints as well as hear them. So that's kind of exciting. So yeah, I would encourage you to become a Tax Place member. I'm glad you're here listening today to this podcast. Seems like the theme of today's podcast is just things that could happen to anybody. I know people like to hear that when you're listening to a legal podcast, but sometimes these things just come up, and I want to talk about almost like preventative, how to think about these things and just avoid issues. So I have 2 Court of Appeals cases that came out in early July that I want to talk about. One is about prescriptive easements, and the other is about divorce and farm families. And then the last thing I want to talk about is that we are starting to get more questions about property tax assessments, specifically for agricultural land and agricultural property. So I kind of want to talk about, if you think you have agricultural land, you think the property's been misclassified, what to do, what actually is agricultural real estate. So we're going to talk about all of that today. But to get started, I want to talk about a case that happened just a couple weeks ago. The Iowa Court of Appeals heard a case about a prescriptive easement, whether it was created or not, for a gravel farm road. So for those who don't know, a prescriptive easement is created when one person uses another person's land. You have to use it openly, notoriously, continually, and hostilely, in good faith, for at least 10 years. So in this case, there was a farmer who, you almost need to see this on paper to understand how the diagram works for the farmland. But basically, he could not get access to his parcel of land without using this gravel road. So in order to get to the southern parcel, as he called it was 300 acres, he had to travel on gravel road that bordered his property and his neighbor's property. The gravel road had running through it an easement by a utility company with different poles. So because of his large farm equipment, he had to go off the gravel road a little bit, a few feet onto his neighbor's property in order to get his equipment down there. So that worked fine for many, many years. But then in 2015, a new landowner purchased the neighboring property. That landowner then started to build a fence. So between the fence and the utility line, the utility poles, the farmer could not get his farm equipment down to his property. The farmer filed for an injunction. He was able to get one, and he claimed that he was entitled to access the gravel boundary, specifically part of the land on his neighbor's property, through either prescriptive easement or boundary by acquiescence. He was basically claiming that that was his land now because he had been using it for so long. So not only do you have to use this land for 10 years openly, notoriously, continuously, and hostilely in good faith, but additionally, the Court of Appeals stated that you have to also give the true owner express notice of the claim of their land. So the issue in this case was specifically, did the original owner know that the farmer was using his land as if it was his own? So the farmer had to show that he had this as a matter of right. And the farmer had used this land, these few feet, to travel to and from the farm for many years. However, the original owner, he knew about it, and he just thought he never had talked to the farmer. He just thought this farmer was using the gravel road because he had permission to. There's no evidence that just because the farmer was using the gravel boundary line that he acted like it was his own. So the Court of Appeals found that there was insufficient evidence to show that there was an express notice of this claim of right over the boundary, because the original landowner probably was just assuming that the farmer used the land because he was allowed to use it, not because he owned it. So in this case, it's important to realize that just because you use property does not mean that it's yours. You have to use it, and the owner, the true owner, has to have noticed that you are using it as if it is your own and that you are claiming it like it is your own. So that is kind of the rub here. And you see these cases all the time where somebody is able to get the land through adverse possession or prescriptive easement, by acquiescence. Something happens where someone ends up losing land. So it's important to make sure that you know what's going on your property. But if you gave permission to someone to use their land, they're not using it what's called hostilely, that they're not using it contrary to what the owner would want. So, or how the owner is using it. It's good to remember this stuff, that it's really easy to lose land. Just remember to know what's going on in your property and not let this happen. So in this case, the farmer did not have access to those few feet, and he was going to have to figure out a different way to get his farm equipment down to his property. The other case that the Court of Appeals issued earlier this month was about farm divorce or divorce on the farm. So unfortunately, this stuff does happen, where in this specific case, a couple had married in 2006 but separated about 10 years later. So at issue was the amount of child support that the husband owed. The wife worked 2 off-farm jobs, and the husband worked full-time managing 2 pig nurseries. The husband also rented 80 acres of farm from his mother, and he rented another 40 acres from someone else. So on this 120 acres, he grew crops and raised cattle. The farmer, or the husband, claimed that this farm was more of a hobby than an actual business, so that his salary, this farm salary, should not be taken into account when determining child support. In Iowa, there are guidelines to determine what child support obligations should be, and we have the system to prioritize the best interest of the child, because each parent does have a duty to provide financial support, but that financial support really comes in proportion to what the parent's individual income is. So in order to calculate the amount of child support, a court has to determine the net income of a parent. And the net income is calculated, and there are certain deductions that are subtracted from the gross income. So the husband was arguing that the farm expenses and depreciation costs should have been taken into account when the court determined his salary for the farm salary. Deductions for depreciation expenses are not specifically included in allowed deductions, but there has been Iowa Supreme Court cases in the past that has held depreciation can be acknowledged in child support determinations, but this isn't a hard and fast rule. It's really it has to be analyzed on a case-by-case basis. So the district court have found that the husband earns an extra $45,000 per year through his farm operation. There was a lot of different factors that I think played into this. Is that the trial court believed that the husband was not a credible witness and that he played a bit fast and loose with his affidavit. The district court, after taking this all into account, found that the husband made an extra $45,000 per year through his farm operation, and they included that number in determining the amount the husband should pay in child support. But like I said, this calculation did not include depreciation expenses and other farm expenses. So the Court of Appeals did agree that the husband was playing a bit fast and loose with his financial affidavit, but when it looked at the Schedule F, it did for the 5 years prior, it found that there was significant expenses for both farm expenses and depreciation. When the Court of Appeals deducted these expenses, it determined that the farm really was just a break-even operation, and that over a 5-year period, the husband only netted about $3,100 annually. District Court had done the math and thought the husband farmed enough to earn $45,000, and the Court of Appeals found that the number is closer to $3,100. So, a $42,000 difference did really add up. The Court of Appeals said that the depreciation expenses should not be allowed to create income losses in order to avoid paying child support. but there were valid farm expenses that when there are necessary business expenses, that can be deducted from one of the parents' gross income when you are determining child support. So the Court of Appeals found that the husband's farm expenses should have been just subtracted from his gross income in order to calculate that child support payment. The court held that the average $3,100 should be used, not the $45,000. So that is a big difference, and it made a big difference in the amount of child support that was calculated. The lower court, the district court, had also held that the wife was entitled to an equalization payment. The lower court had mentioned that, when the wife had paid for many different things that were, like rent and debts, car debts, things like that. But when she had gotten hurt at work, her payment always went to paying the bills. But the husband's salary went towards things that were more fun, like vacations, internet, cell phones, things like that. So the Court of Appeals did affirm that the wife was entitled to an equalization payment. However, they thought that you could not use the $45,000 amount that the district court had calculated, but instead they had to use the $3,100. So instead of the $70,000, which is about half of what the husband would earn over 3 years, they said she was entitled to the $10,000, or that's about 3 years of the farm income. So even though she was entitled to it, they had to do the math differently to include the farming expenses. And that, this is a case that unfortunately divorces on the farm do happen. It's interesting to see how courts are trying to make things fair, but also at the same time not let people get out of paying for child support payments, because you do want to find what's in the best interest of the child, but you have to do that proportionally. So that's a case that, it probably comes up more than we see, and it is really sad, but it's good to realize that how finances can play into an issue like this. One other topic that's been coming up here at CALT is about property tax assessments. Now, we've been getting some calls about how property is assessed and how to appeal different property classifications. So I want to give a little overview on how this works. And the Department of Revenue also has a lot of great information on their website. But just to begin, the county governments have the duty to collect property taxes from the state, from the citizens here. So in these taxes, as you all probably know, fund various things such as the city government, the county government, school districts. But to determine the amount of property taxes a person owes, the county assessor has to establish the classification of each property. So each county has its own county assessor and own county assessor office, and as well as several cities have their own. So the Department of Revenue has created different rules for how to classify and value real estate. And that is one of the main duties of the county assessor, is to assess the property according to its present use and determine what type of classification it should have. Property can be agricultural, residential, multi-residential, industrial, and commercial. Because of how costly this can be if something is misclassified or misvalued, you can understand that there can be quite a few appeals of what a county assessor has decided. So in 2005, the Iowa legislature created an agency that's called the Property Assessment Appeal Board, or PAB. And this was created as a way to streamline the property assessment appeal process. So if a taxpayer wants to contest some part of a tax assessment, they first have to appeal to their own county board of review. Then if that is not in their favor, they can appeal to PAB. So you can appeal tax assessments for inequity, market value, misclassification, error, fraud, or changes in value. A property is valued according to its actual value, and that's the fair and reasonable market value of the property. And then there's a lot that goes into this with how the average of the property values combine, and it gets a little bit complicated. That's not the duty of the county assessors to determine the tax, but to determine the value and the classification. So it seems recently there's been some controversies with how agricultural real estate is classified. According to the Iowa Administrative Code, agricultural real estate is land and buildings which are in good faith use primarily for agricultural use. So while this does not include residential buildings for humans, that agricultural purpose includes growing crops and fruit trees and raising livestock for profit. So this PAB has heard several appeals regarding misclassification of agricultural real estate. And there's 3 cases that I want to talk about that have happened recently. One case that came out this past April for Dallas County, a taxpayer owned a little over 25 acres, and on the property he had a house, a machine shed, 2 livestock sheds on his property, and he also had 2 horses. So he testified that one horse was almost 20, but one was under 5, and he had wanted to breed the younger horse, but he had not done so yet. He also testified that this landowner wanted to purchase cows and other small livestock as 4-H projects for his children. And so it doesn't really seem to be an issue what type of livestock you have or whether horses are livestock or what this is, but the main issue in this case for the taxpayer in Dallas County is that there is really no intent to profit. And that is why the county assessor had changed the classification of the land to residential. So the land had been used as a residence for the home since 2011, and it had been used for, keeping horses and growing hay for those horses. And so there was agricultural activity occurring here on this property. However, there was no good faith attempt to profit. And that is what the issue is that the property and the horses and all the livestock on it that he had talked about was just for enjoyment. Obviously, if he would have the horses for breeding or giving riding lessons or racing or really anything that he had attempted to make a profit, this might have been a different outcome. However, there was no current use of the land to make a profit. And he had talked about future goals, but future goals such as acquiring more cows and livestock, and that but there was no actual concrete plans, and there was no profit motive for this future hypothetical plan. So while he did also use the land for hay production, he only used it for his own horses, and there was no evidence that there was any income from this activity. Because there was no intent for profit, he did not establish that the property was misclassified, because even though there was livestock on his property and he was growing hay, he had met that portion of the definition, but because there was no intent to profit, his land was correctly classified as residential. I think it's interesting to see from this case, it doesn't really matter. Agriculture can be so many different things now. Agriculture is changing. There's a lot of different things that people do now to create money, like agritourism, that maybe they didn't before. And so it doesn't necessarily seem to come up what the issue of how they use it, but whether there's an intent for profit. So that was an interesting case to see, and that just happened in Dallas County this past April. There's also 2 more cases in Humboldt County where 2 farmers had land closer to town. So in this next case, there was a farmer who owned under an acre of land with a 3,600 square foot metal building on it. So he had about 560 acres of row crop land where he grew corn and beans. He also then had a little parcel of land closer to town. So he used this agricultural building for storage and maintenance of his equipment. The court asked why he didn't have it on his land, and he had presented evidence that they decided to purchase the land because they built their maintenance shop closer to town, that because it was closer, he was able to save money on mechanic costs and do a lot on his own. This land was on a gravel road. It had no sewer or water, and he had to bring electricity in, and it was surrounded by cornfields. So there was other metal buildings surrounded it that were used for farm storage, and there was one commercial property near it. But basically, the issue here is, what does this taxpayer, this landowner, use this shed for in this less than 1 acre parcel of land? So the taxpayer bought this land as an investment in order to reduce the time of travel to and from town for material and parts, and also allowed him to take better care of his farm equipment and then extend its life. So because of the reduced costs and hiring a farm mechanic, he is able to save, he estimated, almost $23,000 a year. This farmer is also involved in other businesses. He was a sales manager and involved in the construction of hog facilities. But when you're assessing property, it doesn't necessarily matter what you do, it's what the property does. Even though he had off-farm jobs, he didn't perform any of those duties for his other jobs at this facility. So the county assessor needs to determine what is the use of the land, what's the current use. The taxpayer did admit that he used the building for some personal endeavors. He has a child with special needs, so he did make some custom toy accessories. He also stored an ambulance there that he would use to a service vehicle that he used to help transport his child with special needs. But this was not a profit motivated type of thing, and he no longer makes those toys. Even though that was a small portion of the property, or a small portion of what the land was used for, it was what is the primary purpose. So in this case, the PAB board decided that no, this actually was agricultural and this land was misclassified. It was not residential. The PAB believed that the land was in good faith use for agricultural purposes because the taxpayer intended to purchase the property for ordinary agricultural purposes, and that it seems that he was going to continue to farm. He had hundreds of acres of land he was farming. He was a fourth generation farmer. There was no intention that he was trying to get out of farming. So even though the building had been used for some agricultural purposes, those uses were never the principal purpose. So this should be agricultural. So that was reversed, and then the land is now classified as agricultural. So there's also another case where this neighbor in Humboldt County of the first taxpayer, he also had a large shed on a little over 1 acre site. So he used this utility building in a very similar way to what the other taxpayer from Humboldt County did. Again, this farmer, he had some off-farm jobs. He also owned an excavation business, but he was a fourth generation farmer that used the shed to store his farm equipment. So the building was constructed in 2009, and until the 2017 assessment, it was classified as agricultural. And the Humboldt County Board of Review and the taxpayer agreed that the use of the land had not changed. The shed was still used to store agricultural equipment, but the land around the shed had changed, and that's why it was changed to commercial. This taxpayer farmed about 700 acres of land. He also owns a drainage and excavation business, but never was the business used, his excavation business never used the land for the business. It was only used to store farm equipment. This taxpayer testified that when his equipment is outside, it would depreciate by 10 to 20% more each year, and that he could not have built a shed on his farm property because he did not have the room without compromising some of his road ground. So the county assessor did not believe that this was for agricultural purposes in good faith to make a profit. However, PAB did not agree with that. They held that this was another fourth generation farmer who obviously wanted to make a profit, and while he did have different side ventures and he did store a boat and different things like that in there, the primary purpose was still agricultural. So you can see how these last two cases are different from the first one, from the man with the 2 horses, where there has to be an intent to profit. It doesn't matter necessarily the size of the property because PAB did reverse the 2 farmers in Humboldt County and decided that even though they only had about an acre of land each, that was still for agricultural purposes. Because even though it was not connected to their farm, there's no requirement in the Iowa code that these properties stay connected together. So hopefully you guys don't start running into these problems where you feel like your property has been misclassified. But if these things do happen, I'm gonna have links to PAB and how property is supposed to be classified. But just remember that if you're using your land, no matter the size, for agricultural purposes with an intent to profit, that should be classified as agricultural and not commercial or residential. But if you have something that's agricultural, like you raise dogs or horses or something like that, that if you don't mean to profit from it, then that's not agricultural. It's also important to note that there's no actual requirement to profit. You just have to try to profit. So I think that's important to realize in this farm economy, when money is tight right now, that it would be a huge issue for about every farmer if you had to actually make a profit, unfortunately. So this podcast was really about, unfortunately, things that could happen to anyone. It's important to kind of know what your rights are, and so it's important to know how these things can affect someone, whether it's, easements of property, divorce, misclassification of your real estate that really ends up hiking up your tax bill. I hope none of you have to go through this, but it's good for us to learn from other people's situations. If you guys have any questions, feel free to give me an email. My email is kwtovar@iastate.edu. Again, I hope you guys don't have to run into any of this, but I know these things happen. Coming up, we do have our September seminar, so if some of you might be interested in that. It's taking place in Ankeny, September 23rd to 24th, and it's online. So we're going to have an agricultural law seminar on the first day, and that might be interesting for some of you. But I hope you guys all have a great weekend and enjoyed the podcast. So have a great day.